Quarta sessione, buongiorno a tutte, buongiorno.
We're beginning this session, and at the end of this meeting, I think it was quite right to select the issue of new tools which can be used internationally and nationally to combat discrimination. The principle of non-discrimination has its roots in a number of fundamental acts of the Union, starting from Article 2 of the Treaty establishing the Union, and Article 10 on the Treaty on the Functioning of the European Union also has a cross-cutting clause which aims at covering the combat against discrimination and the definition of EU policies. Furthermore, the European Union can directly adopt regulations which prohibit discrimination on the basis of nationality. Council specifically can define specific measures to combat discrimination based on gender, race or ethnic origin, religion or personal beliefs, disability, age or sexual orientation. The scope of these measures to combat discrimination is completed with the use of preventative measures and measures to combat racism and xenophobia in Article 67 on the Treaty on the Functioning of the European Union. And finally, we need to bear in mind that the European legal framework has been bolstered by the inclusion in the treaty of the Charter of Fundamental Rights of the European Union. Article 21 enshrines the prohibition of any form of discrimination based on gender, race, color of skin, or ethnic or social origin, genetic features, language, religion, personal beliefs, political opinions of any other nature, the belonging to a national minority, as is birth, handicaps, and sexual tendencies. In the legal framework, of which I've only outlined the basic traits, the primary legislative activity between 2000 and 2014 has been intense and diverse. The attempt to find increasingly effective instruments has not stopped and should guide action directed to the public union in order to support actions to combat discrimination and foster access to justice, and also the struggle against discrimination, which Roma are particularly the victims of. In seeking all these targets, it's necessary to promote integration in the cultural processes which all citizens of the member states should be participants of. Thank you for your attention. With us I open the fourth session of the meeting of the chairpersons of committees specialized in fundamental rights, and we have two very authoritative key speakers who will be listening to in this session. That's Asylum, who's chair of the Gender Network, and Marco Perellini, who is a member of the International Secretariat of Amnesty International. Zeljko Jovanovic, for reasons of health, will not be able to speak to us. He is director of the Roma Initiatives Office at the Open Society Foundation. This will be followed by a discussion. As previously, the time allotted to the discussants will be based on the number of discussants and the time available, and the need to allow some time for the keynote speakers to reply. And so those who wish to take the floor in the discussion should fill in the forms which you have in your folders. And I now give the floor to our keynote speakers, asking them to keep their statements to 10 minutes. Dr. Silovic has the floor. Mr. Chair, colleagues, members of the European Parliament, I'm very sorry that I'm not able to speak Italian today, because I think it's more simpler for me and better for you not to.
It is my honor and privilege to be here today, and thank you very much for this opportunity to speak about human rights. But I would like to use the case of the status of women and gender equality as a proxy to the question of, overall question of human rights, fundamental freedoms. Since I think that the way we deal with nearly 50% of our population is not a minority issue, with all due respect to the minority issues. It is actually the fundamental question of how do we want to see our societies of the future, and how do we want to develop our rights, responsibilities, and freedoms. And therefore, I have taken that question of gender equality, which is basically a social construct, as an indication of the state of human rights and some of the questions that can lead to the tools and the instruments, especially for parliaments, to deal and to ameliorate the status and the situation. Moreover, that question of gender equality relates to both individual and collective human rights. It relates to our democratic institutions and our democratic establishments. It relates to the question of social justice, of equality, and equal opportunities. But having said that, the question is also not static. Human rights and the status of citizens is not a static issue. This is something that has to be monitored, that has to be addressed, and where we have to be vigilant. Because if I were to contextualize, and I think the previous speakers in the sessions, starting from the introductions by Signora Boldrini and Signor Grassi, and this morning by Minister Alfano, have actually pointed out to the context in which we are discussing this question in Europe, in which we are now discussing this question. And what is the context? The last European parliamentary elections have seen a good turnout in terms of the right-wing parties and the nationalistic parties and the xenophobic parties, which of course does not ring well for democracy and the way we want to see Europe in the future. The economic and social situation and the recession we have experienced recently seems to be slipping again. And some of the predictions that we have in front of us are actually showing the possibility of slippage into a new economic recession today. So where do we go with addressing the issue of men and women in our societies from the perspective of their human rights, social justice, and equal opportunities? I will use Southeastern Europe as an example, as anecdotally. That region is only now really coming out of the war of the 90s. But what did the war of the 90s bring? It's quite shameful. In terms of women's rights and human rights, it brought in xenophobia, nationalism, but it also brought in rape as a war, as a war instrument of war, and hence we haven't yet internalized the resolution 1325. However, the countries in the region have changed constitutions and have introduced positive laws. But if you look at those constitutions and positive laws, you're actually going to see that sometimes they look a bit like Emmentaler, lots of loopholes and lots of holes. And a lot of that still is wanting. The question, for instance, of violence against the gender pay gap, we are all throughout Europe experiencing that women are less paid than men. Martin Schulz had this as one of his European Parliament electoral campaign slogans. If you look at violence against women, which is out of 47 countries in Europe, the Istanbul Convention that was promoted by the Council of Europe, 36 countries have signed on to it. And only 14, including Italy, have ratified it. In the region, it was Albania, Bosnia, Herzegovina, Montenegro, and Serbia. We might want to look into the reasons why other countries in the region have not ratified that convention. And moreover, the question of violence is by default seen as a question of family violence. It's easier. It's not such a strong, I would even say, ideological or secular issue. It's easier to deal with violence against children than against women. But actually, it is against the individual, whoever that individual may be. The issue of reproductive rights. If you look again at the constitutions and the legal provisions, you will actually have that litmus test where the society is. But you'll also come to a position to look at a different problem, and that is the problem of the enforcement of the secular state that has been enshrined, for instance, in the constitutions in one way or the other, in one language or the other in the countries in the region. We see very often flagrant acts against the constitution in that sense, whether they come from the church itself or whether they come even from the executive. Recently we had a case where the taxation unit adjudicated that a donor could not be tax exempt, which is by law, because the contribution was to a Center for Women's Studies, which was for freedom of choice and reproductive rights. Fortunately, the government reacted, and we have seen that every time when the law enforcement or the parliament or the government react, things may work out best. There was a lot of talk about migrants and migration and immigration and that burning issue in Europe. There was only, I think, one mention of trafficking. Trafficking has been rampant. Fortunately, it seems that we are managing to deal with it, but it does, and I would like to, I would like to express my admiration for the Italian government to raise all these issues in terms of looking at it holistically across Europe and thematically, holistically and comprehensively. The question of migration and immigration in the region of Southeastern Europe has primarily in the recent 20-year history been dealt with the question of refugees from one part to the other and one country to the other. But if you look at it differently, the reproduction of the workforce, of labor, in view of the birth rates and in view of the brain drain is going to cause a lot of problems in terms of dealing with the questions of immigration in the area. I still think that there is not enough understanding of what it will mean, and that the governments are ready to start dealing with that. So the measures are basically addressing the gap in the constitutions and in the laws, mainstreaming gender concerns in the different legal provisions, whether they directly deal with gender equality or labor laws, health and social security laws, etc., etc., accompanied by budgetary provisions, because what's the law if you can't put it into practice, if you cannot implement it, if you cannot enforce it, and if you cannot finance it? Affirmative measures and capacity development. On violence against women, we've seen that law enforcement and social welfare offices are not equipped to deal with these things. Affirmative measures, I must say, really positive measures work. I'll give you the example of the United Nations, where I've spent the last 20 years. When a program on violence against women, gender mainstreaming, and other issues, human rights issues, were instituted as a precondition for employment and contract, and nobody could go into the field without passing the test, things are changing. I must tell you, and I would love to see this implemented also, and I'm now going to finish on the European Union. I'll also like to see this to be introduced for European Union officials, staff members, consultants who are coming into the region to advise on accession, the acquis, the legal provisions and others, so that they are sensitive to the issue of human rights, to the issue of minorities, to the issue of gender equality and so on, up front. Because it will cost us much more to deal with these issues post festum than it would cost us to actually have this as one of the preconditions. And there has been a mention of the lack of understanding on the gender issue. The European Union provisions in the acquis and everything that's been doing it, actually doing it lip service. There's no more time for complacency in Europe, whether it's political, it's economic or social. It's a question of how that Europe will be actually the Europe of citizens. So we've heard one excellent presentation the first day on the fundamental rights and what Europe has done, but frankly speaking, as Mr. Martin Kierum has said, the question is, do our citizens really know about it? And what can they do about it? There is one more issue, and I think I'll finish on time, and that is the question of leverage. And that relates to that question of complacency. Can the European Union leverage and pressure? And I think for the implementation of human rights, and it was raised here by our Turkish colleague, by Honorable Radin from Croatia, but in Croatia it was also raised by the Serbian minority party leader who said, since Croatia has entered the European Union, there's no more leverage, there's no more pressure, because there's nobody to pressure. So where's the pressure coming from, and where are the sanctions going to be, and how then that will be dealt? And of course the parliaments are key in making that pressure happen. Thank you very much.
Grazie, Presidente.
Thank you. And now I'd like to give the floor to Marco Perolini from the International Secretariat of Amnesty International.
Onorevole Presidente, onorevoli.
Mr. President, members of Parliament, ladies and gentlemen, thank you for inviting me to this meeting. I will be speaking about the legal instruments that exist at European level and new legal instruments that the European Union should adopt in order to combat all types of discrimination. In 2012, the European Union was awarded the Nobel Peace Prize for having contributed to the advancement of peace and reconciliation, democracy and human rights in Europe. Indeed, the European Union did adopt in the 70s already many instruments to fight against discrimination between men and women, and then in the year 2000, 2 new directives were adopted, and then in 2008, a criminal law instrument to fight against racism and xenophobia. Despite this, we still see a stagnation in the European role, in its role it should play at regional level to fight against all types of discrimination, including sexual orientation-based discrimination and gender discrimination. And we hope that the new Commission, the new European Parliament, will contribute to speeding up work in the European Union on this. I will speak in particular about 2 areas: hate crime and fighting against all kinds of discrimination over and above employment. It is necessary for the European Union to introduce new legal tools, but it's also necessary that the existing legal tools be implemented in a satisfactory manner. And above all, the European Union must have an internal strategy to promote human rights. within its territory. So, on the first point, hate crime, there are instruments. The most important one is the 2008 framework decision to combat racism and xenophobia. Despite this instrument, well, it's a very limited instrument because it deals only with violence based on racism and xenophobia and it doesn't protect against crimes against sexual orientation and gender identity. It doesn't look into how the crime should be investigated and how they should be prosecuted. One of the most important things for hate crimes is the problem of how the authorities, the police, the judiciary, how they should investigate the acts behind this. And there are still many gaps in investigating these issues and how they are dealt with during the trial. So, of course, there is another instrument as well for victims in general, but it is unclear how this instrument can be implemented in such a way as to really take into account the special needs of victims of hate crimes. So just to give you some examples, Michelle is a transvestite who was attacked in Catania in Italy. She was attacked because some people had realized she was a transvestite from her physique and from her voice. And despite the fact that she was attacked because she's a transgender, during the investigation and during the trial, the transphobic element could not be taken into account explicitly because in Italy there is no provision for this. Similarly, Christina's son in Bulgaria was killed by a group of skinheads in a park in Sofia. And despite the fact that the aggressors were caught and are undergoing trial at the moment, the homophobic element that was quite clear from the dynamics of this assault and cannot be taken into account because in Bulgaria there's no legal provision for this. So we believe that at the European Union level, or the European Union should play a part in making sure that these gaps are filled in all member states. And in order to do this, the European Union must review the framework legislation dating back to 2008, which does not include certain elements like gender identity and sexual orientation. The second topic I'd like to address is what should be done to combat all types of discrimination. Here, as I've said, there are various instruments that are very important and that have already been adopted by the EU. The problem is, however, that they are restricted. They do not protect against all types of discrimination, as, for example, employment. Or within employment, when it's a question of sexuality, of religious belief, of disability. These elements are not covered by the existing legislation. Now, apart from these serious gaps, There are problems also concerning how the existing instruments are implemented. So one of the 2000 directives deals with all discrimination having to do with ethnic origins. But despite the fact that this directive was adopted, there is still discrimination going on in the Czech Republic, Italy, France, Romania, concerning Romas, for example, when it's a question of access to housing or education. So it's not just important that these legal provisions be adopted, but you also have to have them implemented in a comprehensive manner and an effective manner. So this means that infringement procedures must be introduced against the member states that continue to discriminate against the Roma in the countries I mentioned, for example. To conclude, there are therefore four main areas where we believe the EU should do more to combat effectively against all types of discrimination. First of all, generally speaking, at European level, what is lacking is a coherent strategy to fight against discrimination and to ensure and protect human rights. To fight against discrimination, or the fight against discrimination, should be a main area within justice and home affairs policies. The second area is to revise the framework decision of 2008, and therefore this decision, this framework decision, must include sexual orientations and gender identity, but also age and other elements. And then new directives should be adopted so that in the member states, this discrimination element linked to these hate crimes be properly investigated and prosecuted. The third element has to do with the adoption of a new directive to fight against all discrimination. The EU in 2008, more than 6 years ago that is, did adopt a proposal on this matter, but it's still under discussion in the member states. So this draft directive should be adopted so that some of the gaps I've mentioned are filled. The fourth area is implementation of existing standards, that is to say, concerning discrimination on basis of gender, race or ethnic origins. The EU must continue to see to it that there is an effective monitoring of these standards and the infringement procedures be introduced against the member states that continue to discriminate against ethnic minorities, for example, the Roma, who are protected by the directive of the year 2000 against discrimination on the basis of ethnic origin and race. So we think that these new instruments and the proper comprehensive implementation of the existing tools should help to improve combating all types of discrimination, including sexual orientation and gender identity-based discrimination. Thank you.
Per le accurate
Thank you to all the speakers for their presentations. I would now like to open the debate. I have 4 people on my list of speakers for the moment, so I would say we give the floor to each one for 4 minutes so that then the speakers will have time to respond for 6 minutes. The first person is Madam Turman from Turkey.
Riza Turmen.
Riza Turman.
Chairman, well, when we are talking about discrimination, we should be aware, we should bear in mind that we are talking about a set of hegemonic relationships. We are talking about domination of one ethnic group over another ethnic group. We are talking about domination of one religious group over another religious group. We are talking about domination of men over women. We are talking about domination of heterosexuals over LGBTs. And unless and until we terminate such hegemonic relationships, discrimination will prevail. That, I think, is very important. And the most important, the most effective instrument to this end is education, of course. We must be able to teach in our education systems to young people, to children, that people, regardless of their sex, of their ethnic origin, of their religious belief, that all people are very, very equal. That, I think, is very instrumental. I would like to touch upon a very specific form of discrimination, a more subtle form of discrimination, which is called an indirect discrimination, which can be defined as a policy or practice that creates a substantial disadvantage for a group of people without the intent to discriminate. This, I think, has been improved, this definition, as to encompass not existing formal practices, but also more informal practices. And such a discrimination, indirect discrimination, I think is particularly important for discrimination against women. Because that when a certain practice or a law applied to a condition which would also apply equally to a man, but which is such that proportion of women who can comply with it is considerably smaller than the proportion of men who can comply with it, that, I think, creates indirect discrimination. And also, which cannot be shown to be justifiable irrespective of the sex of the person to whom it's applied, is also an indirect kind of discrimination. One of the very good examples of indirect discrimination is a case that was decided by the European Court of Justice in 2007, the case of D&H and others against Czech Republic, where the children of Roma origin were sent to special schools. The court in this case decided that the difference in treatment between Roma children and non-Roma children was not objectively and reasonably justified, and found a violation of Article 14 of the Convention. When we are seeking of ways of combating indiscrimination, Mr. Chairman, I think the European Union should urge both member states and candidate states to become party to Protocol 12 of the European Convention of Human Rights. This, I think, will enhance the ability to combat effectively against discrimination, because Protocol 12 gives the power to the court, to the European Court of Human Rights, to scrutinize the national legislation of the states. And it is unfortunate that so far very few states have become parties to this protocol. This, of course, will put the national legislation of all the states that are parties to the protocol to be examined from the angle of discrimination by the European Court of Human Rights. And this, I think, would be very important in combating effectively against discrimination. Thank you.
Grazie.
Many thanks. I'd like to give the floor to Deborah Schembri from Malta.
Thank you very much, Mr. Chair. Discrimination is very arbitrary. We sometimes forget how arbitrary it is. If we look at people with their fundamental human rights and we look at people with rights just because they are humans, then we realize how discrimination, how arbitrary discrimination is. You could be discriminating against blue-eyed people, you could be discriminating against the blondes, just like you discriminate against women and you discriminate against transgender people or LGBT people, because there is no fundamental difference between all of these sectors. There is nothing to the distinctions that we make except arbitrariness. And therefore, if we realize that when we talk about rights to people who are LGBT people, rights to women, we are really giving the rights that somebody took away for no good, valid reason. We are not giving extra rights to LGBT people. We are not giving extra rights to women. Nobody is asking for extra rights. We are just asking to be given human rights to these people. And I think as soon as we realize how basic and fundamental this is, then we start making the necessary changes without too much complaining, without governments making so many obstacles. And I think and I must agree with the previous speaker, that one of the most effective tools that we've got is education. And when we say education, we don't just mean what we say, but we also mean the books that we teach on, for instance, because we have a lot of gender distinctions in books. We have a lot of stereotypes in books, and therefore we need to revisit what we teach on, the material that we teach on, because automatically, even though we don't say it, we give the impression that something is wrong when we discriminate even in our books, and therefore that is something to take note of. We have also forms of discrimination that are new maybe to our times. Sometimes we speak of women and of LGBT, and we have also discrimination about the traditional forms of family versus new forms of families, even in our schools. And when you have certain kind of promotion of Mother's Days and Father's Days, and you have sometimes children feeling cut off because they don't have that sort of thing. So we need to, without lessening the importance of certain important issues and certain important days that we celebrate, we also need to take into consideration that we are in an era of blended families and different sort of families than we might be used to, so that we don't discriminate in the education system. We also need to, besides education, we also need the basic core laws. We need laws in our constitution. For instance, Malta, in the past year, has added to the non-discrimination part of the constitution gender, non-discrimination against sexual orientation and gender. And the gender issue is we are basically the only member of the European Union who has added non-discrimination with regards gender in the constitution. I think more countries should follow suit. We have also made changes in the criminal laws. We have heard speakers speak before about problems that they are finding because there are no criminal laws in place. We have made these changes, and in the past few years we have progressed a lot. We have put on our law books civil union legislation not to discriminate against LGBT people and same-sex people in unions, and therefore we need to have a broad approach, laws and effective ones. We had before, for instance, legislation which said that a transgender person could have change in the ID card, in the identification card, but they weren't given the rights that came with it. They weren't given the rights to marriage. We also changed that, and therefore it is important not to just have laws on paper, but to make laws effective ones, to make effective changes. We also need, besides education and laws, we also need better environment conducive to non-discrimination. For instance, if you have a transgender person, a transgender student in a school, which bathroom does that transgender person go to? If that transgender person goes into a male bathroom, the male counterparts object. If in the female bathroom, the female counterparts object. And therefore, we need to come up with solutions. For instance, in America, now there are, in certain universities, unisex bathrooms also introduced. They have introduced certain universities regulations that you can choose to use your own name, the one that you wish to be called, rather than the name on the birth certificate, just so that people don't discriminate against. We need to be a little bit innovative in how to combat discrimination, but I think first and foremost, and I end on this note, we need the political will to do it. A lot of the stumbling blocks are not stumbling blocks because of big finances or things that have to that need a lot of big changes. We need a change of mentality, and we need to push forward rights by realizing these are fundamental, basic human rights, not extra rights for anybody who is discriminated against. Thank you.
Grazie.
Thank you. I'd like to give the floor to Ahmet Yemaya from Turkey.
Chair. Bana saldırı savaşları mı yoksa ayrımcılık mı daha büyük hastalıktır diye sorsalar kesinlikle ayrımcılık derim.
War or discrimination, if I'm asked whether war or discrimination is worse, I would definitely answer. My answer would definitely be discrimination.
Dünyayı kasıp kavuran sosyal bir patoloji alanını tartışıyoruz.
We are now discussing a social pathological field which ravages the globe.
Nereden kaynaklanırsa kaynaklansın, bölge, ırk, ideoloji veya din farkından kaynaklanırsa kaynaklansın, ayrımcılığın savunulabilir bir gramlık yeri yok.
Whatever its reasons or motives, geography, race, or even religion, it has no means to defend it.
Ayrımcılık istikrara, kültüre ve insanın kendisinin savaş ilanıdır.
Discrimination is equal to declaring war to the global stability, global culture, and the humanity itself.
Ben bu anlamda pozitif ayrımcılığı anayasacılığın ve insan haklarının bir sapması olarak görürüm.
In this sense, I regard positive discrimination rather a distortion of the constitutional and other legal basis.
Semantik olarak değil elbette, sözcük olarak. Çünkü pozitif ayrımcılığın ifade ettiği değeri tamamlayıcı eşitlik olarak anlatmamız lazım.
Not in semantical means, we should rather see the positive discrimination as a complementary argument of other freedoms and liberties.
Ansiklopedilerin dahi tüketemeyeceği zor bir sorunu konuşuyoruz.
We are now discussing a very problematic issue that even the encyclopedic information can fall short of addressing.
2-3 hususa dikkat çekmek istiyorum.
I would like to draw your attention to a few issues.
Bir defa dinler arası ayrımcılık gerçekten bugünün mantığıyla baktığımız zaman anlaşılabilir değil.
It is impossible to understand when taken into account from today's perspective, the interfaith discrimination is something hard to understand.
Bilim adamlarını ve ilahiyatçıları sorgulayacak değilim.
I am not in a position to question the overall framework brought by the scientists and the scholars.
Ancak Avrupa'nın erken dönem oryantalizmine rağmen bu konuda sağladığı ivmeyi, pozitif gelişmeyi özellikle belirtmek istiyorum.
However, I would like to point out the progress made by Europe despite its early age orientalism.
İtalyan meslektaşlarımın Gaetano'nun cilt cilt bu konuda kitaplarını değerlendirmiş olmalarını düşünüyorum.
I hope that my Italian colleagues have benefited the books written by Gaetano.
20. asrın başında Osmanlı'yı en az 20 yıl entelektüel olarak bir depremle karşı karşıya bıraktı.
The Ottomans have been had to face a intellectual earthquake in the first years of 20th century.
Bu konuda çağdaş düşünür Edward Said'i rahmetle anıyorum.
And in this sense, I would like to commemorate Edward Said for his contemporary contribution to this issue.
Sanıyorum insanlığın her dönemden daha fazla hoşgörüye, sevgiye, sanat ilgisine ve tabiat aşkına ihtiyacı var.
And I believe humanity needs more than any time feels a strong need for tolerance, love for human, and an interest for culture.
Bilinç mühendisliğini yapmaya mecburuz.
We need to perform an conscience engineering.
Öğrencilerimize ayrımcılığın en az öldürmek kadar tehlikeli ve kötü olduğunu anlatmalıyız.
And we need to train our students that discrimination is no worse than killing a person.
İnsanlık mantığı ekseninde düşünmek istiyorum.
I would like to take this issue around a logic of humanitarian conscience.
Vatanımız bir, dünya vatanı.
We have one territory, it is the globe.
Dilimiz bir, gönül vatanı.
And we have one language, which is the language of heart.
Ontolojimiz bir, insan ve hakları.
And we have only one ontology, the human and his rights.
Acaba insanlık ayrımcılık düzeyi sıfır, kusursuz bir barış çağına ulaşabilecek mi?
And I wonder whether the humanity can achieve a lasting level of peace and triangulity.
Bu tatlı bir ütopyadır.
And this is a very pleasant utopia for us.
Benzerliğin gücünü ve farklı olmanın zenginliğini kavradığımızda çok şeyi çözmüş olacağız.
When we recognize the power of similarity, I believe we will already resolve all the issues which are still haunting us.
Sizlere tekrar gönülden Mevlana sevgisini
I
sunuyorum.
would like to present my wholehearted greetings from Mevlana Celaleddin Rumi.
Teşekkür.
Grazie.
Thank you. Central Giudice, Italy. I'd like to start from one consideration. There are lots of ways, more or less effective, to deal with direct or indirect discrimination, but any type of action must have one essential facet: to identify a situation of discrimination as existing. In my opinion, this is one of the main obstacles to combating discriminations which are linked to situations which are not consolidated in the cultures of countries over history. I'd like to take the example of Roma and Sinti peoples. There's not a uniform understanding that the situation of the Roma and the Sinti is a situation of unjust discrimination. The same thing goes for gender identity and sexual orientation, where all too often, despite what is the statements of the European Union, the directive, and the statements of the European Parliament, which have said that this kind of attitude is equivalent to xenophobia and racism. Inside a country's culture, at least this is my opinion, and even inside the political class of states, often these are not seen as conditions of discrimination to be combated. Just to give you the example of Italy, a law against homophobia and transphobia has not yet been enacted because some political forces believe that no problem of homophobia and transphobia. There's no discrimination against LGBT people, and a law against homophobia and transphobia would be a inappropriate and unreasoned limitation to the principle of freedom of expression. So unless the object of discrimination is clearly focused, it's very difficult to decide which situations and which measures need to be deployed in order to combat this situation. Clearly, a more effective action on the part of the European institutions could be very helpful. And I would like to comment on the delay which the directive on discrimination and situations which go beyond what is specified in Directive 43/2000, things which go beyond the workplace and which go beyond discriminations based on ethnic origin, and the Directive 78, which refers to other areas of discrimination but only restricts the scope to the work site. It would be very useful to have a much broader directive so as to have regulatory measures promoted in member states, but also to provide operational measures. For example, if Directive 43/2000 allowed the member states of the European Union to have an independent body to combat discrimination based on people's race and ethnic origin, member states are not required to have a similar measure to combat discrimination in other areas which are included in Directive 78, disability, sexual orientation, etc. And I would like to finish with one comment. There is a very significant problem of institutional and political discrimination. On the 17th of May this year, the International Day Against Homophobia, the Agency for Fundamental Rights of the European Union published the results of a very interesting survey on 93,000 interviewees, which indicated, among other things, that in many European countries the issue of discrimination on the part of politicians, discrimination therefore in political language, and institutional discrimination was particularly felt. And so it's important for member states to encourage the European institutions to adopt a cross-cutting directive, and also that in states there'd be reflection not only on the regulations to adopt and also the way politics relate to such a sensitive and thorny issue, namely access to fundamental rights on the part of the whole population of the European Union.
Grazie, io passerei ora.
Thank you very much. I would now give the floor to the speakers again for their replies.
Thank you very much. I'll actually agree, and I cannot disagree with Mr. Thurman. I agreed with you yesterday regarding the question of sanctions and the question of enforcement and pressures. I think you're absolutely correct. It's a question of hegemonic relationship, and this is what really is bogging us down. On one hand, you're instituting the laws. On the other hand, you're having a huge vacuum in terms of the education system, in terms of the change of the patriarchal and the traditional, and that is not even, that is very slow to take even in educational systems. We've had an issue in Croatia recently where the government tried to introduce health education in schools, including sexual education, sexual rights and diversity, and it met with a very vehement opposition by the church. And some compromises have been made, which is, of course, which we are very sorry for. The second issue, intent to discriminate, without the intent to discriminate, that's exactly what I was thinking of, mainstreaming the issue of human rights and equality and gender equality in that sense in the different laws and that are passed in the parliament, so that one law does not negate the other, but actually that this basic tenet of our societies in the 21st century permeates. We have an interesting case, and this is where I spoke about the European Union and the enforcement of that throughout the advice and the support given particularly to accession countries, is the case of Sejdić-Finci. Some of you may have heard about it. The Dayton Agreement specified that, and the Constitution of Bosnia and Herzegovina provides that only ethnic Bosniaks, Serbs, and Croats can be elected as members of the presidency. And Sejdić, who is a Roma, and Finci, who is a Jew, have actually gone to the European Court of Human Rights, have been vindicated. They applied in 2006. There was a ruling, and in 2011, Bosnia and Herzegovina started or wanted to start the change of the constitution. Now, I was in Sarajevo two weeks ago, and I was told basically that nothing happened, and if we look at the elections from this Sunday, that may be also indicative. To Dr. Schembri, I would like to congratulate you. Actually, today you must feel a bit vindicated, because you were spearheading the divorce law in Malta, and today we are hearing that the Catholic Church is discussing that issue. I think kudos to you. There is a vacuum, and if you look at the situations in Hungary, in Romania, in Bulgaria also, there is a vacuum between what we have asked to be the criteria for accession, the acquis, and everything else. So it's not accompanied by broad educational, societal, and other action, so that you can make a map that can actually correspond to the Europe of today and tomorrow. If you only look at the question of corruption, irrespective of the laws, it is still there. We haven't yet got there in terms of the culture. I would like to congratulate the Italian Parliament and the question of the declaration on the internet. One may want to revisit that from the perspective of this discussion, including on the gender issue. I think it's that's the crux of the matter, is really how to make it happen throughout the legislation. The Roma minority and my network organizes annual meetings with members of parliament on these issues, and we have actually seen that the discrimination of the minority, national minority, ethnic minorities, and so on, actually and religious minorities, happens at 3 levels. Roma women, I'll take them for example, but we are seeing this happening with other groups in more or less different environments and intensity. The Roma women are discriminated as women within the society, because we haven't got there yet. They are discriminated as a minority, as members of a minority, and then they are discriminated again within that minority. So we are having triple discrimination. And therefore, I think it needs a concerted action, and I would really like to thank you for raising these issues in these 2 days, because I think we are all going to go back richer, and there are the initiatives which are trying to spearhead, which are very laudable. Thank you.
Grazie.
Thank you. Yes? Thank you. I'd like to comment what was said by some representatives as to the fact that sometimes the political discussions when draft bills or legal instruments are being discussed in national parliaments, the fact that all too often there is the belief that if you adopt a bill against discrimination, it creates extra rights for these groups. This is very dangerous. And this belief exists in various European countries at the moment, especially concerning anything that restricts the definition of matrimony, of marriage, to marriage between man and woman. Now, on this respect of human rights, the fact that members of parliament and governments shoulder a great responsibility. We've spoken about legal instruments and the adoption of new ones, but there's a whole series of preventive measures and mechanisms that governments and parliaments should promote. And one of these is, as a member of parliament or a member of government, try to change things when it comes to discussions on human rights. It's true. Often the adoption of new policies or new measures or new legislation is difficult because there's no political will to do so. And this was said on the matter of a new directive, as I was said too. The 2008 directive that isn't adopted yet in the member states. Well, sometimes parliaments can be the motor, the catalyzing element, as the European Parliament was when it came to this new legislative instrument. But then there's the problem of the limited competence of the European Parliament when it comes to the adoption of this new instrument. The European Parliament obviously does not have the same competence that national parliaments do in this field. And this means that the member states must approve this instrument unanimously. What is a good thing is that the new Commission, the new President, has said that it is necessary to move forward when it comes to the adoption of this directive, even though we still don't know exactly how this can be done after 6 years of discussions in Council. It's still not clear how the new Commission or the new Commissioner will be able to get out of this stalemate situation. And I also believe, well, somebody mentioned, I think it was a Turkish colleague, mentioned the ACA ruling, and we're talking about regional level legal instruments now. It's within the Convention for the Protection of Human Rights and the Council of Europe. Well, the Council of Europe has often promoted many of these instruments. But then, of course, you always have the problem of the adoption of these instruments at national level. But there are many other rulings and sentences that have come up against the same problem, like the ones against on discrimination against Roma children, and even in Czech Republic, Italy, France, and Romania, there still is discrimination, unfortunately. Implementing this sentence is still an important point. And then there's the more general point of the European Union signing the Council of Europe Convention for the Protection of Human Rights, and we don't know how this will be done yet. And again, as I already said, the role of the European Union when it comes to implementing the existing instruments that combat discrimination in the fields where the European Court for Human Rights has already found breaches of the convention. The ACA ruling against the Czech Republic exists, but there is also the possibility for the European Commission to introduce infringement procedures against those countries that still haven't implemented the 2000 directive on discrimination against ethnic minorities. So here, there has been a recent development, this introduction of an infringement procedure against the Czech Republic on this. It's a very important element, and we talked about the access of Roma children to education in the Czech Republic as in other countries. Here, finally, the European Union has introduced this infringement procedure against the Czech Republic, but we think the Commission should also be firm when it comes to other issues in other member states. And more generally, as I said during my presentation, I think it's important that the European Union reflect on how to make sure that all the existing instruments and new instruments belong to a single coherent strategy to protect human rights within the European Union. This strategy does not exist yet. We don't have a comprehensive European strategy at the moment that will make sure that human rights are respected within the EU.
Grazie.
Thank you. Thank you, colleagues. Well, I close this fourth session and therefore close the conference of chairpersons of the committees specialized in fundamental rights. I thank all the speakers for their very precious contribution. I thank you all, colleagues, for having actively taken part in the debate. These have been two very intense and interesting days and have allowed us to discuss issues that are at the heart of the idea of Europe and that are our common heritage. Guaranteeing fundamental rights during an economic and social crisis with very considerable migration flows and other elements that may endanger all these rights. Also the use of the web, eliminating all types of discrimination. These are all challenges that the member states and all the states taking part in this meeting must tackle together. The conference is therefore closed, and I invite all the participants to come for the ritual photograph on the staircase that leads to this room, and then you will find indications as to where the lunch is. I'd like to remind those who are interested that after the lunch there will be a guided visit in English and French to Montecitorio. I wish you a safe journey home and hope to meet you again very soon.